Okay, let's bring this meeting of the Board of Adjustment to order. Madam Secretary, would you please call roll?
Clay Thomas,
Here.
Christina Hill,
Here.
Lee Lawrence,
Present.
Red Stanley,
Here.
Kim Toulouse.
Here.
Do we have a quorum?
Thank you, Madam Secretary. Ms. Hill, would you please lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Mr. Edwards, the ethics law announcement, please.
Actually, it'll be Mr. Large from our office reading that today.
Thank
And
you.
I'll make a more specific announcement about that toward the end of the meeting, but he and I are both going to be here today for this one, but he'll read the announcement today.
Excellent, thank you.
Board members are reminded that if with any respect to any matter or any person coming before the board today, you have received a gift or loan, you have a pecuniary interest, you have a commitment in a private capacity such as family, employment, business, or similar relationship, or you provided representation or counseling before an agency to a person or an entity for compensation within the last year on a matter being considered. You must disclose that gift, loan, interest, commitment, or prior representation at the time the matter is being considered. And you must furthermore abstain from deliberation or voting on the matter if it is clear that the gift, loan, interest, commitment, or prior representation would materially affect the independence of judgment of a reasonable person. Board members are also reminded that under the Board of Adjustment rules, if you have had any contact outside this meeting with any persons interested in a matter coming before the board today, you should disclose the nature of that contact at this meeting.
Thank you, Mr. Large. Mr. Lloyd, would you please read the appeal procedure?
Most decisions rendered by the Board of Adjustment are appealable to the Board of County Commissioners. If you disagree with the decision of the Board of Adjustment and you want to appeal its action, you may do so in writing within 10 calendar days from the date the decision being appealed is signed by the Secretary of the Board of Adjustment and mailed to the original applicant in the proceeding being appealed, in accordance with Washoe County Code. Please call the planning staff immediately at 328-6100 for information on the appeal procedure and application fee.
Thank you, Mr. Lloyd. Next on the agenda is general public comments. Any person is invited to speak on any item on and off the agenda during this period. Action may not be taken on any matter raised during the public comment period until the matter is specifically listed on the agenda as an action item. Madam Secretary, do we have anyone wishing to speak at this time?
We have no public comment.
Thank you very much, appreciate that. Next is possible action and approval on the agenda. Is there any discussion, first of all, on the agenda? I'll take a motion.
I'll move to approve the agenda.
Thank you. Second?
Second.
Ms. Hill, second. All in favor?
Aye.
Aye. The agenda is approved. Next is possible action to approve the December 6, 2018 minutes. Any discussion on that item? Thank you. I will accept a motion.
So moved.
Thank you, Mr. Stanley.
Second.
Thank you. All in favor?
Aye.
Motion carries. Next, we'll move on to the public hearing. The first item that is up will be special use permit case number WSUP 18-0021, Sunray Construction, previously SB 05014, which was Sonoray Roofing. We have someone from planning, Ms. Mullen, thank you. Before we get started, are there any disclosures from the board on this matter? None? Thank you. The podium is yours.
Thank you, Mr. Chair. Good afternoon, members of the board. I'm Kelly Mullen, Senior Planner with Washoe County. And this hearing, as you know, is for Sonoran Roofing, also known as Sunray Construction. The project site is located at 1565 Geiger Grade. That site is accessed directly off of Kivett Lane. It involves two parcels that together are just at about 1 1/3 acre. Both of those parcels are zoned general commercial. So just to give you a brief summary of the request, there is an existing construction, sales, and services use type on site. With Sonoran Roofing, they are a roofing and HVAC, heating, ventilation, and air conditioning contractor. They were issued a special use permit for this use back in 2005. However, the proposed expansion that they're seeking right now does trigger a re-review of that special use permit. And what they are proposing to do is add on 3,570 square feet to the existing 3,636 square foot metal storage building on site. The purpose for that expansion is to allow for materials and equipment to be stored indoors. Right now, there is a good amount of material being stored outside that is exposed to the elements, and they are wishing to bring that inside to protect it further. On the site plan here, you can see that north is to the left on the screen. On the left there is Geiger Grade. On the top is Kivett Lane. Property is bordered on the right-hand side, the south, by King Lane. Again, primary access is off of Kivett Lane through that smaller parcel. The area with the red hatching identifies where the proposed expansion would occur. On this photo, you can see the properties again. Here, north is to the top, and you can see that there are general commercial properties bordered on either side to the east and west. Across Geiger Grade to the north are residential properties. There are additional residential properties to the south. From this site photo, it was taken from the Kivett Lane entrance, showing that existing structure. Same existing structure, however, this photo is taken from across Geiger Grade. This shows the approximate area of the proposed expansion, and all those materials, again, that are being stored outside would be brought indoors. And here you'll see an existing pallet storage area that is on site right now. The initial special use permit allowed for that storage to be up to 4 feet in height. One of the proposed conditions of approval does memorialize that as well. Additional project details, again, bringing that material that's currently stored outside, bringing it in. There is no expected traffic expected to be generated from the expansion. There are 5 employees currently that are based on site. Expected that a max at any given time may be up to 12. And we would require that standards for parking, landscaping, and lighting from the development code would be met for the entire site upon that expansion. In terms of some of the aesthetic considerations, this expansion would help to screen the operation from Geiger Grade, as that addition would be just south of Geiger Grade. There is an existing chain link fence with vinyl slats around the majority of the perimeter, and per the conditions of approval, that would be filled in so that all areas around the perimeter would have that slatted chain link. The previous conditions of approval from the 2005 special use permit did have aesthetic conditions also. Part of those required that the color and building materials of the structures on site match. That would be continued with this expansion. The applicant has requested that the materials and the color match on the north and east sides of the addition, but they have requested for only the color, not the building materials, to match on the south and west sides of the expansion. Those particular areas, south and west, that would be more internal to the property. Staff does believe that that request is feasible and would be in substantial compliance with the 2005 conditions of approval. And those original conditions would simply become part of this special use permit. They would be added to the new special use permit conditions. This item was heard at the January 3rd South Truckee Meadows Citizen Advisory Board. We did not have any members of the public who asked questions or had comments. No questions also from the board itself. They did vote unanimously to recommend approval of the request. Notice was provided in accordance with code standards. We did send this out to a variety of different agencies for review, and you will see that there are some proposed conditions of approval included with Exhibit A. Those are standard conditions expected to be imposed on this project. With the conditions of approval, staff does believe that the required findings for approval can be met, and we are recommending approval of the request. If you agree with staff's recommendation, a possible motion is displayed on the screen. With that, I'd like to conclude my presentation. I'm available for any questions. Thank you.
Thank you, Ms. Mullen. Are there any questions on the board? No? Thank you very much.
Thank you.
Appreciate that. Is the applicant present, and do they wish to speak on this item? Please state your name for us.
Yes, my name's Rob Lauder. I'm an engineer with RL Engineering in Carson City, and I'm representing the owner, John Daly, who is also here. Basically, we're here to answer any questions you might have.
Okay, thank you very much. Any questions? No? Thank you, sir. We appreciate that. Madam Secretary, is there anyone from the public that wishes to speak on this matter?
We have Bruce Bacon.
Thank you.
So please forgive me if my voice cracks a little bit.
Can you just
I live
state your
on
name?
King-
Can you please state your name for the record real quick?
Oh, I'm Bruce Bacon. I live at 1530 King Lane, 89521. And I think I bought the property in '96 and moved in the following year. So there's been significant changes in the neighborhood. What I found when I investigated this SUP, I'm an old-time surveyor, okay? So first thing I did is I saw the only access, the recommended access is through a parcel. And in the 2005 SUP, it was required to be boundary abandonment and a merger so that that property could never be sold and destroy the access from Kivett because it's a little congested on highway. So that wasn't done. And the only concern I had was that there's a gate that comes out into King Lane, and if that parcel were to be sold and go away and not have access to Geiger Grade, all the traffic would come in and out of King Lane. King Lane is already overburdened. It's a 50-foot, at one time owned by Washoe County as a public easement. It's unimproved other than drainage ditches and road-based material that I've been maintaining over the years, trying to maintain, but one of the neighbors who has an SUP actually in the same vicinity, first thing the gentleman did was fill up the drainage ditches, which has affected all of King Lane. So I know that some of the engineering requirements are very vague, but in my experience, anytime a commercial use or other intensifying uses usually would require street improvements. Now, I'm not asking for street improvements, but I am asking that the parcel be completed as per first SUP in 2005. And I'd just like to say as a general comment, I think it's a lot easier, your job's kind of hard, a lot easier for you to prove these SUPs than to find that they're in violation and actually be able to do something about it. So I may be before you again on a different matter, but on the same street and the same issues.
Okay,
Thank you so much.
thank you. Are there any questions for this gentleman? Okay, thank you. Madam Secretary, is there anyone else wishing to speak on this matter?
No, we have no more public comment.
Thank you. We'll close the public comment and bring this back to the board for discussion. Any discussion?
You've got a member in the audience trying to indicate he wants to speak.
I'm sorry, we'll go ahead and back up then and allow the representative for the applicant to come to the podium.
Again, for the record, my name's Rob Lauder. Just wanted to respond to the gentleman's concern about the two properties. I believe that the documents that you have include in the conditions that the two parcels be made one before a building permit be issued.
Thank you for clarifying that. I appreciate that. With that, we will go ahead and close public comment and bring it back to the board for discussion. Any discussion? Mr. Stanley?
I would be curious to hear what the answer would be to the SUP issued some years back, whether or not, in fact, that was executed completely and properly. So could we ask the planner to come back to answer that question, or what do you think the best way to address that might be?
Ms. Mullen, would you come back to the podium and assist us with this question?
Happy to. Thank you, Mr. Chair, to the board member through the chair. In terms of whether or not the previous special use permit was completed as initially planned, to get back to the public comment regarding the reversion to acreage, that was a requirement. With the 2005 special use permit, it looks like that reversion to acreage had not occurred. That is why we do have as condition 1F with this special use permit that be completed prior to building permit. Were you interested in other details beyond that as well? Okay, thank you, Ben.
Any other questions? Thank you. Would you hold off right now for us? It's back with the, it's before the board right now. So, are there any other questions? Yes.
And this would probably be for Ms. Mullen again. My question is, if that was a condition of approval on the original SUP, and it's now also a condition of approval on this SUP, who's watching to make sure that these conditions of approval are met? And if you follow where I'm going with that?
Yes, I do. Thank you for the question and the opportunity to clarify. I may have misspoken previously when I said it was an actual condition of approval. I'm just going to double check that. I know it was listed in the staff report and had been proposed. You just bear with me, please. And it doesn't look like that was an actual condition of approval, but again, it was included and had been proposed and was listed in the original staff report, so we would be memorializing that with this condition of approval. I do want to point out, though, that if there are any conflicts between the original conditions and the new conditions, the stricter would apply.
Okay, thank you.
Mr. Lewis, that's fine. Any other questions? Mr. Stanley?
Yes, again for Planner Mullen. Obviously, I thought it was a nice note, by the way, to have the more stringent of the two SUPs, the conditions abided by, so that the more recent would override or essentially supersede the other one. But the question that was raised earlier, what is the actual process? This one seems a little easier because you can't build anything until this is done, right? So there's a almost date certain on that in terms of, well, not really, but there's certainly a can't go forward until. If that weren't the case, what is the process for seeing that the conditions are in fact met if there's not a contingency built into them? In other words, if it weren't contingent upon, you won't be able to begin construction until X. How would that be addressed?
Thank you for the question. So certainly that is something that I know current practice is to ensure that there is some sort of a time or trigger that's associated with conditions of approval. It certainly makes them easier to enforce and make sure that they have been met when we have that element in there. But in terms of just general process, we do check for conditions of approval at various stages moving forward. Certainly if, once the building permit is submitted, we should be checking for conditions of approval at that point, as well as the other agencies that are involved. Also, again, for, say, a new business prior to issuance of business license.
And one more, if I may.
Sure.
And as follow-up, the timing for pulling plans might be what? Can you speak to the anticipation on when permits and so forth might be pulled?
So I would defer to the applicant's representative in terms of the specific timing, if they have that planned. We do have a condition that requires that building permits do need to be issued within 2 years of the date of approval by the Board of Adjustment. So it would need to be within that timeframe.
And one follow-on. If, in fact, 2 years is a long time these days, so if for an example, there were a sale that took place in the next year or so, would this SUP, it would no longer be valid under a new user or a new owner, is that correct? What does that do to the SUP?
So actually, the special use permit does reside with the land. One of the things that we do request is that if a property is sold or, business changes hands, that the new owner does meet with us to make sure that they understand the conditions of approval, but they would still be valid. Assuming that, of course, that the project does begin to move forward, if it's within that 2-year time frame, that the use doesn't change to something else, et cetera. So if it was to be the same use, if they were to sell the business as is to another property, not change any of the aspects of the use, the special use permit would be valid.
If I may, my question was a little different.
I'm sorry, Mr. Stanley. Can you please speak into the microphone? This is for the recording secretary's benefit when they prepare the minutes.
Is that what these are for?
Thank you.
Thank you. So I was actually contemplating what would happen if the one section that currently is going to be built on under the new permit is sold, since it apparently is a separate parcel, is that right?
No, the addition would actually happen on the same parcel where the existing structure is. I'm just going to bring this back up, this site plan, so we can clarify that a little bit. So you'll see on the left-hand side of the screen, there is an existing structure there just to the right of where the red hatching is. And then the red hatching is the proposed expansion, and that's all part of the same parcel.
I see. So a sale should not have any effect then?
It should not. Now, in terms of, and I guess I don't want to misanswer your question. If you're getting at something specific, do you mean in terms of the sale of one of the properties, say the property to the east, as opposed to the main
Actually, I
parcel?
was trying to address the gentleman's public comment to see what kind of impact that would have and what would govern after sale, let's say.
Certainly, that would be a concern. That is one of the reasons that we did require the reversion to acreage, because there is, that both of those parcels had been included and were part of that original special use permit. We want to make sure that going forward, that it is all part of one parcel, especially because parking is used on the property to the east for this business, and certainly they've landscaped part of that area as well. So we consider the development as a whole and want to make sure that they do stay as one parcel moving forward.
Thank you.
Thank you, Mr. Stanley. Any other questions from the board? Okay. With that, I will accept the motion. Mr. Stanley?
I move that after giving reasoned consideration to the information contained in the staff report and the information received during the public hearing, the Washoe County Board of Adjustments approve with the conditions attached as Exhibit A, the special use permit case number WSUP 18-001, previously known as SB 05-014, for Sunray Construction, having made all 6 findings in accordance with Washoe County Section 110.810.30 and Southeast Truckee Meadows Area Plan Policy, SETM 111.3. And this includes consistency, improvement, site suitability, issuance not detrimental, effects on a military installation, and air quality.
Thank you. Mr. Stanley, can you just repeat the special use permit case number one more time?
Sure. WSUP 18-0021.
Thank you. Is there a second?
Second.
Thank you, Mr. Toulouse. All in favor?
Aye.
Motion carries unanimously. Okay, moving on to item B on the agenda is Code Enforcement Appeal Case Number WVIOPLA 18-0259 Carroll Drive. Ms. Olander, that'll be up to you. But before we get started, are there any disclosures on this item from the board? None? Thank you very much. Ms. Olander.
Good afternoon, Julie Olander with Planning and Building. This is a request to hear an appeal of an administrative hearing officer's decision on a code enforcement action regarding the height of a fence in the front yard setback. The property is located at 5235 Carroll Drive, and it's approximately 31,000 square feet. It's located off of, in the Sun Valley area, as this map shows. Just to give a little background on the enforcement requirement, enforcement is per Washoe County Code, Chapter 125, Administrative Code, and that's enabled by 110.910.15D. And the administrative enforcement procedures include processes of warnings and then escalating penalties if the violation is not corrected. And the issuance of an administrative warning is the first step, and typically, and they have 30 days to correct the violation. So the background on this particular case is that on May 25th of 2018, a complaint was received concerning junk vehicles being stored on the property, someone living in an RV, and then a structure that was in disrepair. Upon investigation by the code enforcement officer, those items, that was confirmed on the property. Also, there was a 6-foot fence that was surrounding the property, including along the street in the front yard setback. And here's a picture of that fence. So just to give you a little background, a 6-foot fence in the front yard setback is a violation to the code. And a violation was issued for that fence being in the front yard setback, and the owner had 30 days to remove it or alter it. So you can have up to a 4.5-foot fence in your front yard in that front yard setback, so that fence could be altered to be 4.5 feet. Property owner stated that the previous owner had obtained a variance in the 80s for the fence after the property had been cited for a violation, and the judge had ordered that a 6-foot fence be put on the property to screen the property from the items that were on it. It does appear that that fence has been there for some time. The farthest I could go back was to 2000, and looking at photos, I could see that the fence was located there. I couldn't tell how tall the fence was at that time, but it has been there for a number of years. The property owner made no changes to the fence, so the code officer issued a penalty notice on July 18th, and the property owner appealed that penalty notice. On August 15th, the case was heard by hearing officer Elizabeth Byer, and she recommended the following: that the property owner was given 60 days to find the notice, the document that said that the Sparks Justice Court required the 6-foot fence, and then also to go back to the original complainant and find out if they still had issues on the property. The owner was not able to locate the document. Our staff was able to find the document, but later on in the story, so I'll talk to that a little bit later, but the document was not found while it was still before the hearing officer. The hearing officer also requested a legal opinion from Washoe County to confirm that the code officers had the right to, or the authority to cite a property for a violation that was not on the original complainant, or the complaint. The opinion was stated that the CEO, the code enforcement officer, does have that ability to cite violations, even if they aren't on the original complaint. On November 5th, the hearing officer issued an administrative order dismissing the violation, and the hearing officer stated that the debris had all been removed, and the fence violation was, this is quoting what was in the, from the judge, merely Washoe County Code Enforcement's bootstrap methods to have the property owner clean up the property. And here is that section of the order. And I apologize that didn't get into your original staff report, and I believe that was emailed to you this morning, and then a hard copy was given to you. This is the section of code that the fence requirement is from 110.406.50A, and that is what it states. It says that a fence has to be no more than 4.5 feet high if it's in the front yard setback for residential properties. This property is zoned medium-density suburban. And just wanted to point out, the Washoe County Code is our sort of go-to to give us guidance on how residential properties should be developed, which includes fencing, setbacks, height, and landscaping. In some developments, you have HOAs with CC&Rs, and other properties don't, and so it falls back to the development code to give the residents some guidance of what they can and can't do on their property concerning development. And 110 is what is our sort of go-to for that. So I also went back, found that the fence height is the same since 1982. I cut out a portion of the 1982 code. Again, it states that 4.5 feet is the height. Anything can be, if it's a fence or anything grown like shrubs and so forth. And then it refers to except as provided in paragraph B, subsection 3, which I also put in there. And as you read, subsection B is, there shall be no planting, fences, shrubbery, or other obstructions to vision more than 3 feet in height, that the curb level within 20 feet of the intersection of any streets. So there's an exception, but that's for corner properties on corners, so there's no blocking of, for traffic reasons. But the basic understanding is even since 1982, fences can't be any more than 4.5 feet. So this is just that street, Carroll Street. I wanted to show some other views of the fencing in the area. Again, one of the reasons we have fencing requirements is to make it look residential. We don't want it to look industrial. You typically find the 6-foot fence in a more industrial area. So the 4.5-foot fence provides privacy and can contain pets typically, and yet still gives a sense of the residential look. Public notice isn't required for an administrative enforcement action. The only noticing that is required is to the violator, and that was provided through due process. The appellant had been provided notice, and so those processes that had occurred earlier, the CAB is not involved in this administrative enforcement action. And no other agencies are also noticed for the same reason. There aren't really findings in this situation. The BOA is not required to make findings. The public record is sufficient. A written order for the BOA decision will be prepared and executed by the BOA chair and filled out by the secretary of the BOA, and then a copy of the order is served to the appellant. And then if appealed, if it's denied, there's an appeal process that I'll show you at the end. Here's a possible motion, and then here's the appeal process. And I'm available for any questions.
Thank you. Are there any questions from the board?
Yeah.
Yes, Mr. Luce.
Ms. Mullins,
No.
did you make any effort to find a variance that was issued by building, or by your department back then?
Yes, I apologize for not speaking to that directly. Yes, when that was first brought up, that there was an order from the court, we went through our buildings code permit process, which is maintained well by our building department, and we could find no variance. And that's the reason we could not find anything that indicated that a fence was required. And I know I included in your packet information, the court order that came from the judge, the Sparks Justice Court, and it says to get a fence with permits. And so that was not located. There was nothing that showed, there was no variance to allow a 6-foot fence as originally stated by the property owner, which was stated to her from the previous property owner. And there, so we could find no record of a variance nor a fence permit application.
Okay, and then a second question is the court order that you refer to, the one that is in the back of the staff report.
The court order is the one that was passed out and that we
Okay.
emailed to you. That's the final court order. The one you got, the one from the Justice Court is,
It's the one on the back page, I
it
believe,
the
the
back
staff
page?
report, yeah. Okay, and
yes,
just...
that's correct.
Okay, and that's the one where it advises the defendant to put a fence up and get the proper permits. It does not
Correct.
specify a 6-foot fence, and it
Correct.
does not give the defendant permission to build the fence. Is that correct?
Correct.
Okay, thank you.
Yes, Mr. Lawrence.
Yeah, real quick, Ms. Olander. I'm trying to get a feel of when the fence was built. That's what I'm having a problem with. How far did your search for permits go back?
So our search for permits can go back to the 50s and maybe, and sometimes even earlier. They were done in those timeframes on just little cards, but all that has been scanned into our permits, building permit process. So we have access to all of that. We don't always have the details, but we do have that kind of information that a permit was applied for. And it'll also tell us if it was issued or just applied for.
So it's like microfiche or something like that?
No, it's online. We have a process now that we had, and we had a permitting process, probably at that time, probably was just cards, I think, because that was in the 90s. Yeah, I don't believe we had an online process in the 90s.
So
But now
we're
we
not-
do, and all that has been scanned in, so now we have that.
So do we have any idea when the fence was built? Did that ever come out?
That
in
was
all of this?
that was a challenge. I could go back through the online system where we have photos back to 97, and the picture was just too blurry. And in 2000, I could see that there was a shadow of a fence, but as I stated earlier, I couldn't tell. I don't know how tall that fence was. So it appears in 2000, there was a fence on the property. I can't say it was a 6-foot fence, but there was a fence that appears to have been around the whole property where the current fence is located.
Oh, I guess I could have made it easier. What was the date of the court, the Sparks Justice Court, I guess it was, that required a fence to be built with the proper permits and that? What was the date of that decision?
So this decision stated in the bottom, January 29th, 1990.
Okay. That's what I wanted to know. Yeah, I didn't notice it on here. I just wanted to double check. Thank you.
Mr. Stanley?
Thank you. Thank you very much for the extreme diligence to all the details and all the records you could get your hands on, because this seems to be kind of a follow the bouncing ball issue for me. A couple of questions here about the original court decision. There seems to be, there's a reference here for, there's a name, Richard Kisbaugh, and then there's a space and it says Washoe County Planning. Was Mr. Kisbaugh with Washoe County Planning at that time, or? It's in the top absolute right.
So just to clarify, are we talking about this document from 1990?
Yes, 89 is what I think I saw, see it, but
Can you-
yeah.
For the sake of everyone in the audience, can we at least put that up on the screen so they can follow along with the document that's being
Thank you.
spoken to?
And if I may, because I was around back when Mr. Kishbaugh was around, yes, he was a code enforcement officer with our department.
So, I know we're kind of speculating here to some degree, but was he a party to this decision made by the judge? He seems to be the complainant, the plaintiff, and so I was wondering would he have, and thank you for that background on that gentleman, would he have had input to, hey, remember the fence has to be 4.5 feet, or that has to be 6 feet, or underscore the idea of permits, or, I mean, it's a complaint, and he's sitting there, apparently.
So how typically it would work through is that the code officer of this situation is Mr.
Kisma.
Kisma, yeah. And he would have, made the violation the same way that the officer made for the fence that we have now in place, that we're talking about today. So he would have made the complaint, and the original complaint, it looks like it was for debris on the property that was not to be there. And so you can see it went through several months of review, and so it's possible he was, involved in the fence being put up. I don't have any record of that. And again, since a 6-foot fence was not allowed in 1990, because it wasn't allowed since 1982, it would seem that somewhere along the line, something happened on that property that was done illegally in putting that 6-foot fence up. But to say it was under this complaint or later in the date, I don't know when the fence was installed, and I don't believe the current property owner, she is here, I believe, she might have information on if she knows when it was installed, but I believe it was installed before she purchased the property.
If I may? Please. Just to confirm, there's no conflict, or the City of Sparks has no code about this, so Washoe County would be the governing agency over any of this sort of thing, is that correct?
Correct, it's in Washoe County, it's not in the City of Sparks. The property wasn't in the City of Sparks in 1990, it was just heard by the Sparks Justice Court because of
And then,
the
if I
complaint.
may, one more,
Yes.
this last question. This document, proceedings before Washoe County Administrative Enforcement Hearing Officer. This
That
is
one you got
kind of-
handed out this
kind of
morning?
the late-breaking
Yes.
news? Yeah. Could you summarize what this actually was, what the hearing was intended to find, and what it found? And who brought it?
So so what I said, as I stated earlier, there was a complaint made on the property for vehicles, RV, all those three things. And so the code officer went out there to investigate.
Right.
Really couldn't see because there's a 6-foot fence along the property. And a code officer can't go onto the property, they can just cite from what they can see from the public right-of-way. The fence was there, they could see that, over the fence and through the slats, that there were some, those items appeared to be on the property. But the 6-foot fence really inhibited that officer from making that claim, in a sense. So the problem when the officer got onto the property was that they found something that was in violation. Washoe County, our legal counsel gave us, confirmed that the officer does have the ability to cite a property, even if that wasn't in the original complaint. So the 6-foot fence then became the complaint, in a sense. The debris, because it inhibited us from totally clearly seeing the debris and so forth that was on the property, then that 6-foot fence became the issue. However, the hearing officer felt that the 6-foot fence was not of issue. The 6-foot fence had been there. The debris was the original complaint. And as she stated in her decision, that she felt like, Washoe County was just complaining about the fence to get the property cleaned up. Maybe I'm paraphrasing, I should probably go back to the exact words. I
Well,
guess I don't have that option right now. But
just-
anyway, so you have that in front of you, what she said exactly. And so, so she did not see the 6-foot fence as an issue. It wasn't, at least, she didn't make comment of it in her findings.
Okay, so if I'm following this, in 1989, the court said, you're good, put up a fence. Later, there was another complaint or renewal of the same complaint.
Just last
The
year,
C-
too.
The CEO, yeah, so 20 years fly off the calendar in the movie. Yeah. And then a CEO is called to check out the place, says, it kind of looks like, I can't see very well inside, but I notice this fence is too tall. Then comes back, writes it up, then says, since they've cleaned up, if I'm following this, since they've cleaned up the original part, I'd like to delete my concern about, or take it off the books, or withdraw the complaint or the charge against the 6-foot fence, then went to this process with other CEOs and a board, and they said, okay, fine, delete the 6-foot fence charge?
I might have got a little lost in there for
Oh,
you,
so-
but.
so have I. That's the reason I'm asking.
Basically, there were two complaints. There was one in 1990, and that's what we have up on the screen right now. That is the decision for the judge in 1990. And then we have the complaint in 2018.
Right.
And the complaint in 2018 was for the cars that were on the property, the RV, the building that looked like it was in repair.
Right.
So that was the original complaint. When the code officer went out there, he was somewhat inhibited from totally making that complaint. Basically, they take photographs, and that's what they can use as to show that the violation is occurring on the property. Because of the 6-foot fence there, that caused an issue because that's not allowed. We don't allow 6-foot fences in front yards. The property owner, the original property owner before the current property owner could have put a 6-foot fence, but it would have had to been back 20 feet. And they could have still screened the property. They could have had that 6-foot fence 20 feet back from their property line, screen the property in that way. But they chose to put that 20-foot fence right along their property line, which is not allowed. Back to 1982, we can find that it's not allowed. So that when the officer was out there, that, caused that officer to say, wait a minute, this isn't allowed, beyond just these other items that are on the original complaint. At that point, he was given a direction by management to cite the current property owner for that 6-foot fence, because that's not allowed in residential neighborhoods. We don't want, walled neighborhoods. We want neighborhoods, as I showed on that last few slides, that show, you can see the property. They still have, a fenced-in property, but it's, you can see it from the street and so on and so forth. So we're here at 2018 versus 1990, but we're brought back to 1990 because the property owner is indicating that a fence they were told in 1990 to install a fence. And the only thing we can find is that they were to put up a fence, but it had to meet, had to go through the permitting process. We can't find a permit for it. We can't find a variance to allow a 6-foot fence. And so we're now here in 2019, trying to decide, is it proper to have a 6-foot fence in the front yard setback?
I think, and thank you, and I think the part that either I'm making up or that I'm certainly confused about, I'm maybe misreading this because there are a lot of triple and quadruple negatives in this, but did the citing CEO, this century's one,
Yes.
didn't he rescind or call back his citation, or no?
No.
He did
So,
I saw the conversation with the DDA saying, can I do this? And the answer was yes, you
can
can.
I get my Don, get the PowerPoint back up. So the complaint was made in May. The officer went out and so the complaint was made in May. They went out and looked, and that's when they saw the 6-foot fence on May 25th. And then the code officer then in June said a violation for the fence and being in the front yard. And so it was done in June. So the fence was, the violation for the fence was made in June.
And he didn't
And the
then
fence-
later say, don't worry about the fence since you've cleaned up the other thing? I must have misread it then.
Yeah, I'm not sure what you read exactly, but no, the fence was in the complaint in June.
Maybe, let me just step in here, maybe as a point of clarification. At no time in the documents that I read that the order was rescinded by the CED officer. The hearings officer, and that is what we're here before, basically said that they complied with the trash and the rubbish cleanup, and therefore the hearings officer elected to dismiss the 6-foot fence in the front yard.
Thank you.
Are there any other questions? Mr. Lawrence?
Yeah, I have a question. Now, I was to understand there are other 6-foot fences in front yards along this street or in this area, is that correct?
You know, I drove the area yesterday, and there are some other fences. It's hard for me to tell exactly they're 6 feet. It's hard to judge. You know, the ones I showed were at least 4.5 feet. I think there's some other, probably down the street there, looks like there's another one that's possibly maybe 6 feet. I was thinking it was closer to 5. So they are in the area. But code enforcement is complaint driven. It's not proactive. So even if they're in the area and they see other violations, they are not allowed. We are not given direction. The code officers are not given direction to cite those properties. The only exception on this one was that there was a complaint on the property, and does the code officer have the ability to then cite that specific property that they've been called out on of other violations? So if they'd gone to this property and just found the cars that were in disrepair, if they had found maybe someone living in the RV, could they also cite them for that? And the legal opinion was that they could. They can cite for that property any violation that's occurring on that property that they were originally called to.
So it's, in essence, there are other properties there with fences greater than 4.5 feet, be it 5 feet or 6 or 5'6" or whatever, correct?
Yes, I'm sure throughout Sun Valley you'll
Okay.
find numerous places.
And how about, a question I have, has the county, in an effort to reduce eyesores, required 6-foot fences in front or backyards? Does the county have the authority anywhere in regulation to say, you have a dirty, junky backyard, your neighbors are looking at it, therefore, we are requiring you under code enforcement or otherwise to install a 6-foot fence to provide relief for those that have to see it?
If I can answer that, yes, that is a common practice by Washoe County. That is a requirement in order to screen junk vehicles or other violations. That's a very common practice.
Okay. Because I realize that we have, that with cell towers and things like that to screen them as well.
So this is Julia Olander with Planning and Building, just to add one other comment. So we wouldn't ask them to do that. I mean, if there's a complaint and it can be seen from the public right away, then the code officer can cite that property. But they have to be able to see it from the public right away. So if you can see out of your backyard, and I can't see, and I'm the code officer and I'm driving on the street, that isn't always something that we can cite them for.
So with this citation, within it, is the fence being required, what is the requirement that they do with the fence exactly, from the county's point?
If you were to come in and to build a fence and you want to put a fence in your front yard, and you're in a residential property like this one, zone medium density suburban, I'd say you can have a 4.5-foot fence in the front yard setback, then which is 20 feet. From the property owner back, from the property line back is 20 feet. And then after you meet that front yard setback, it can be 6 feet in height. So in the back part of the property, you can have a 6-foot fence. And you don't need a fence permit after you're out of the front yard setback. You don't need a fence permit for that. So you don't need to come into the building department and apply for a fence permit. But if you're building a fence in the front yard setback, you do need a permit for that. And in residential areas, it cannot be any more than 4.5 feet.
So, and I understand that completely. So has the county given them direction as to what to do? Or what options has the county directed them to take?
So initially, what the violation was to ask them to either remove the fence or to alter it to make it 4.5 feet. And that was when the property owner appealed the original violation.
Was there ever an option to go further into the setback with the 6-foot fence? Was that given to them?
No, because then they would have to come in for a variance, because that would be varying the code. Because in the front yard setback, you cannot have a 6-foot fence.
But it's still an option they would have to exercise.
They could come in and apply for a variance, yes.
No,
Oh.
I think maybe you had the question
maybe.
correct. That is an option if the property owners wished to locate the fence 20 feet off of the property line, they would have that option, and that would comply with all county codes.
Okay, I was just wondering if they were informed of that option.
Yes, they were. That was made clear to them what they had to do to make those changes, what their options were.
Okay, so to reduce the fence to 4.5 or less, or move it back within
20 feet.
20 additional feet or whatever, providing a variance is approved for that.
Well, if you're back 20 feet, you wouldn't need a variance. It's
Okay,
only in that
okay.
20 feet you need the variance.
Okay.
In the front, within the front.
So let me get this straight again. They could get a variance to have a 6-foot fence remaining in the same location?
You could apply for one. We would, it would be, yeah, they'd have to show the hardship, just like they have to go through they'd have to meet the findings of the variance. So that's the reason I would say you should not be, you typically will not see anything more than a 4.5-foot fence in the front yard setback.
Yeah, and you're right about the hardship. That's regarding the variance. I'm just wondering, I'm just kind of struggling with why someone would put such an expensive slotted fence, obviously to screen things. Okay, I'll just struggle with that. Thank you.
Mr. Stanley?
To continue with the struggle, and this is really a process question, I think, based at least partially on the question about the variance. Here we have the opportunity of revising or modifying. What are modifications? Maybe as a new kid, I'm not familiar with the options there. I'm not sure how long that new kid argument's going to wash. That's just about year 49. But what are the options for modifying this? Would a variance be a modification option, or what are the options under modify? And if you don't mind, then the same thing, you might address remand as one of our options also, apparently.
Right. At this point, a variance is not an option for this board today.
Right.
However, I mean, you can make that suggestion at some point. However, I think, and again, one of the recommendation by staff is to reverse the decision of the hearing officer. However, this board has the option of modifying, I guess, that recommendation. But
In what way, for an example? What ways are contemplated under the modify clause?
I haven't really explored all of the options. I believe maybe Mr. Geisinger may want to shed some light on that question.
Jack Giesinger, Planning Manager over Code Enforcement, for the record. So that language is a bit challenging, but it's a catch-all set of possibilities for all administrative enforcement proceedings. So they may or may not be useful for a given situation. In this instance, to modify, you'd be modifying the hearing officer's decision in some way. So I suppose you could rule that they were okay to, I'm not even really sure how you would modify it, because basically they dismissed the case. And they based the dismissal on the assumption that the fence was placed there by court order, and that it was, and that there were other fences in the area. There's all kinds of other anecdotal arguments made, and the position of staff was, well, that wasn't the citation. The citation before the hearing officer was not for the junk. They also said that because the junk was cleaned up, the fence doesn't matter. That's basically what they were saying in their decision. So what we're asking the BOA to do is say the fence does matter because it was not ordered to be placed on the front yard setback. It was ordered for screening because this property has a long history of code enforcement action on it. There was actually an abatement conducted on the property. And so you saw the language in the court order. It said recommend installing a 6-foot fence so that they could screen future junk, but it did not direct them to violate county code by placing it on the front yard.
So modification, even though it's vague, could say, go back to the finding of the of the internal investigation.
Well, that would just be simply ruling against our appeal. If you're going to uphold the decision to dismiss the case, then you're basically ruling in favor of the hearing officer's
So that would
decision.
be,
Mr. Chair,
To weigh in.
I think I can try and shed a little bit of light on this.
please.
The language in the agenda item about modification and the other item, or the other possible actions, is tied to the code, because that's what it says about appeals on the code. But if it doesn't have any applicability in this particular case, then you just wouldn't use it. So another situation, perhaps a hearing officer might have said, the fence is fine up to 5.5 feet. And then if it came to you, you could say, no, we're modifying that. It's only fine up to 4.5 feet. That would be a modification. But in this case, if you find there's nothing really to modify, then that option just wouldn't be something that you would consider doing in this particular case.
So am I hearing you say this is a binary choice in this case, in this instance?
Well, the hearing officer just dismissed the violation, so there was no finding, as I read it, that there was or was not a violation. You talked about possibly sending it back and saying, well, was there a violation or wasn't there a violation, of the fence situation? That's an option that you guys have in terms of remanding if you wanted to do that, rather than make the decision yourselves. But in terms of the menu of possible actions for you,
Yes, thank you.
yeah, if one's not applicable, then you just wouldn't consider it.
Thank you.
Are there any other questions for staff? Thank you. Is the appellant present and wish to speak on this matter?
And Mr. Chair, it's the respondent.
Oh, I'm
The
sorry.
the county is the appellant in this case.
You are right, I'm sorry.
She's just not able to speak at this time.
Okay. We'll accept that. Madam Secretary, is there anyone from the public that wishes to speak on this matter?
We have no public comment.
Thank you.
Mr. Chairman, in regard to the respondent and the new documents that were placed in the record today, I want to make sure that the respondent has had an adequate opportunity to review those documents to make sure that all of the due process rights have been, and they've had an ample ability to respond to any of those new documents that went in today in terms of the packet. So I know that you don't want to speak, but we need to know if you had an opportunity to review the packet today. I'm sorry, can you?
I'm sorry, we'd need that, we would need that on record at least, to have someone come to the podium and at least say that, yes, they were able to review the packet and understand the issues that are before this board.
Jessica Richard. I only got the packet on the 2nd, so I haven't had time to do anything.
The 2nd of February, ma'am? Okay. All right. Mr. Chairman, I would recommend in regard to making sure that there's a full and fair opportunity for the respondent to respond to any of these issues, that this board defer this item until the next meeting, any decision on it, in compliance with, in an abundance of caution on the open meeting law.
Thank you, Mr. Large, appreciate that.
Julie Olander for the record. I just would like clarification on what document. She received the packet, as our understanding, earlier. That document is, that's the document that the judge issued to her originally. That's the only thing that, and she should have gotten that at the original code office when she, that was the document that was issued by the hearing officer. So she would have had that, I believe.
Would you, again, can we put it up on the screen so we all know exactly what document we're referencing here? Are we speaking to the administrative order? Is that what we're?
So we're speaking to the hard copy that got handed out to you today, and that should have been in your staff report, but was not. This was issued by the hearing officer November 5th, 2018. My understanding, it was to Jessica Richard, and so she would have received that document in November.
Mr. Chairman, if I may, Michael Large for the record from the District Attorney's Office. I understand in terms of getting the enforcement officer's decision in November, I understand, but in terms of getting the ample opportunity and the notice requirements of open meeting law and the administrative hearing, she's representing that she received the packet on February 2nd. And just out of abundance of caution, in terms of the notice requirements, I would recommend that we defer this decision until the next meeting.
Thank you. I'm a little bit curious as to, when we talk about receiving the packet, what are we talking about? What packet, ma'am, if you could tell me that you received on February 2nd? You'd have to, I'm sorry, you have to come back to the podium and state your name for us.
Jessica Richard, it had all the papers from the original, from the hearing officer's decision. Like all the meetings that we had, it was all that paperwork, and then the paperwork about this meeting, I didn't get it until a second, so.
Excuse me,
I didn't think
Chairman, it is the staff report and the agenda that I sent out to her that she's saying that she received on the 2nd.
I got it.
That's
first
everything
one
I sent to
right
her.
here.
Okay.
If you want.
So it's the staff report that she would have received, that you would have sent, and what was the other document?
A copy of the agenda,
And a copy of the agenda?
yes.
Okay. So that would not,
This was probably,
that would have included all documentation that we have before us.
Not the administrative hearing officer's
okay.
decision that you received today.
Right, all right, and we are making an assumption that this was dated November 5th, and that the hearings officer would have then sent her a copy dismissing the case sometime around that period of time.
I don't know about that.
I mean, maybe for a point of clarification.
Are we back
So,
to
go ahead.
discussion here?
Yes, let's get back to discussion. Mr. Toulouse.
Mr. Chair, I have a great deal of sympathy for the respondent. However, that being said, I'm also well aware of what our task is here today, and technically, we're here to make a decision on the appeal of community development on the hearing officer's decision. My thoughts on this are to offer, and Mr. Stanley's going to hate me for this, but to offer the respondent a continuance to our April 5th meeting, and that would give you adequate time to explore all of your options with the department and come up with an alternative scenario. And that would also kind of suspend all of the actions that are being taken. There would be no more enforcement action, and fines wouldn't build up, all of those things. So that would be my recommendation to this board. And I also want to say one other thing. I'm pretty appalled by Ms. Byers' language in this. Her language that it's a bootstrap attempt by Washoe County, by a code enforcement officer to take action that's not warranted. I'm really appalled by her language, and in my view, she should be censured for that. But that's my recommendation, Mr. Chair.
Mr. Chair.
Mr. Stanley?
One other question. Oddly enough, I'm not at all appalled by the idea of a continuance. I think it's a great idea. With a question to council, does that address your issue of, this to me was late breaking news, and I thought it was extremely germane to the process. So I'm absolutely in agreement with your suggestion. I'm just wondering if continuance also addresses that.
Mr. Chairman, Mr. Stanley. Yes, it would, in terms of making sure that the renotice requirements are met, that we give the respondent a full and fair opportunity to respond to all the things in the packet. The people getting an opportunity to respond is very important and critical in regard to these hearings.
Thank you very much. Thank you, Mr. Chair.
Thank you. Well, I might as well throw my 2 cents in here. I understand the abundance of caution, and I believe that we as a board need to ensure that the open meeting law is followed and everybody gets a fair chance at this, fair shake. But I can tell you, I side with Mr. Toulouse on some of this, and even reading the administrative hearing procedure, Section 8 in particular says, if a hearing officer finds that the violation of code has not occurred, or a violation of code has been committed, but the respondent asserts and proves one or more legal defenses to the administrative penalty notice, that basically they can go ahead and overturn it. And I don't see that. I will remain open to any ideas that come forward to me and to the board, but, I think it's a bit of an uphill battle here, and I will side with council, basically, like I said, under the abundance of caution, and continue this to the next meeting. With that, is there anything else from the board?
I just have one other question here. In all of this, we can stay this till April. Great suggestion, Mr. Toulouse. I think everyone has an opportunity to benefit from that, including myself. Will the hearing officer be given any sort of report of what this board comes up with? Will anything be forwarded to her? Are you aware of that, or is that part of the procedure, or does that become something that she would review at some point?
This board has the appellate power to oversee the hearing officer, and the minutes can be conveyed to the hearing officer along with, as the board is required to issue an order in this matter, could be given to them.
Well, I would just like one thing.
After you take action.
Okay, and in April, of course. And I would like to make one statement that that certainly I agree with Mr. Toulouse, a denigrating statement to the county regarding the bootstrap thing, and that she should re-up for hearing officer training. I have been a hearing officer several times and have presented before them, and I think it's very much less than professional, her approach and her findings and her final comments in this, so that's my point. Thank you.
So, okay, with that being said, I guess, Mr. Large, we would need a motion from the board to continue this?
Mr. Chairman, in regard to Mr. Toulouse's suggestion to put this onto the April agenda, with that the parties work together to convey any avenues that we have, that could be a motion. So move this to be placed on the April 14th agenda. 40th?
I think it's April 4th.
For April 4th agenda, with a recommendation to staff to work with the respondent to see if there's any resolution that can be reached, that all avenues are exhausted.
And that would be done in the form of a motion?
Yes.
Thank you.
Mr. Chair.
Mr. Stanley?
Should we also make note, I noticed in your resolution, you didn't mention an absence of the defendant getting amply supplied evidence in advance?
I think we've already addressed that. So.
Any other, Mr. Toulouse?
I'm prepared to make a motion if there is no further discussion.
Please do.
I'm sorry, Mr. Toulouse, just before you do, in these situations, typically when you continue, you need to get either the applicant or the appellant's permission to move to continue. Being the fact that the county is the appellant, just wanted on the record that, yes, the county does agree to the continuance.
Thank you. Mr. Toulouse.
Thank you. I move that in Code Enforcement Appeal Case Number WVIO PLA 18-0259 be continued to the Board of Adjustment April 4th meeting to be conducted here in these chambers at 1:30 p.m. That's my motion.
Thank you. Is there a second? Mr. Stanley, Mr. Stanley, second?
Second.
All right, Mr.
Mr. Chair, I'm sorry, let me stop right there. Mr. Edwards, do I need to memorialize the request that the two parties get together and try to explore operations, other options?
I don't think you do. The respondents here, community development staff is here. They've heard, the comments, and I think they're pretty proactive about that type of thing. So they're aware of the wishes you expressed and the motion to continue as far as you need to go.
Thank you, Mr. Edwards. My motion stands then.
Thank you. Mr. Lawrence, were you seconding that?
Mr. Stanley?
Mr. Stanley?
Yes, I'd like to.
Second by Mr. Stanley. All in favor?
Aye.
The motion will be we will continue this to the next April meeting. Thank you. Moving on is chair and board items. Is there anything from the board dealing with future agenda items? See that there is none. Requests for information from staff. Does any board member have any requests for information from staff? We have none there. Directors and legal counsel items, report on previous board adjustment items. Mr. Lloyd?
Nothing to report at this time.
Thank you kindly. Any legal information and updates, Mr. Large or Mr. Edwards?
Yes, as you've noticed, Mr. Large is sitting here with me today. We've had some shuffling occur within our department at the district attorney's office. I am keeping some of the planning matters, planning commission and the day-to-day departmental stuff. Mr. Large is going to be taking over Board of Adjustment representation, so you will be seeing him from now on. And he will be your counsel sitting over here, and you're in good hands. He's got a lot of experience. He used to be a federal prosecutor at the U.S. Attorney's Office here in town. He's been with our office for several years now, and he's had a number of different assignments. He has been interested in planning and wanted to start learning, some of the planning stuff in our office. Always wants to cross-train people, so, if somebody up and disappears one day or something, we've got somebody else in the office that knows how to handle some of those matters. So Mr. Large will be your newly assigned counsel. That sounded pretty grim. I didn't mean it for it to sound that grim. That's all. I've enjoyed working with you all, and you'll probably see me from time to time as Mr. Large and I will probably cover for each other on planning stuff for vacations or out of the office scenarios or whatever. This has been my second stint representing the Board of Adjustment. I first did it from 2008 to 2011, and now I've done it for 4 more years from 2015 till now, and it's been a pleasure and a privilege. I've enjoyed it immensely. I have a lot of respect for this board, and I think you all do a very good job. You have a lot of respect for your authority and the limitations on your authority, and I commend that, and I wish you well going forward, and I will see you in the future.
Thank you, Mr. Edwards, and from the board, I believe I can speak for all of us up here that we've appreciated your expertise and guidance on more than one occasion to keep us on the straight and narrow, and you've done a great job. You've always been a good resource for us to call upon when we've had issues that we've been unclear on, and we will miss your presence at the meetings, although we wait with bated breath till right at the start of the meetings to see you walk through the door. And for you, Mr. Large, welcome aboard. We're looking forward to working with you into the future. Next is general public comment. Madam Secretary, anybody wishing to speak?
We have no public comment.
Thank you kindly.
I'm sorry, Mr. Chair, before you adjourn, just wanted to mention to the board that moving forward, all of the meetings will be monthly until otherwise notified.
Thank you.
You going to double our pay?
I think that, that's a lot of money, but yeah, I think we just might.
It's not on the
So
agenda.
is there a meeting in March?
That's a good point.
There is a meeting in March, but my understanding, maybe I was confused, but maybe my understanding that this board gave the respondents 2 months to work with staff.
Okay.
And I felt that was appropriate.
All right. Thank you, Mr. Lloyd. We are adjourned.